Why this should be the year you write your estate plan. If this last couple of years has taught us anything, it's that life is precarious. We can be here 1 minute and gone the next. It's unbearably stressful on your family and costly to face a long probate case after your death. Hi, I'm Ann. I'm an estate planning attorney in Washington State. You can find me at Hartlaw, PLLC, estateplan.com, or email me at hartlawpllc@gmail.com. Estate planning is something that most people don't think about until they're in late stages of life. But in reality, everyone, regardless of age, should consider making an estate plan. Because life is full of unexpected events, it's best to have a plan in place if something terrible were to happen to you. That alone should convince you to get your estate plan done. And while everybody should have an estate plan, there are a few situations where one is absolutely necessary. The first situation is if you are in a long-term committed relationship but have not gotten married. By law, spouses receive a shared assets after death, but in Washington, if you're not married or a registered domestic partner and you die without a will, even if you wanted your long-term significant other to receive your shared assets, they would receive nothing under probate law. It would be up to your family to be gracious enough to give over assets to your significant other, and there might actually be a conflict between your significant other and your family about those assets. And what ends up going to your long-term significant other may not be what you would have wanted them to have. The second situation is if you have minor children. Under the law, the court will choose a family member to become a guardian for your children if you don't have a plan. At that point, you will have no input on who takes care of your children. You'll want to create a financial plan for your minor children for their care and or to receive their inheritance, one that protects the money from misuse or theft. The third situation is if you have a history of dementia, physical and or mental disabilities in your family. If chances are good, you'll also develop these conditions, you'll want to appoint someone to take care of your finances and or your healthcare needs if and when you are no longer able to do so yourself. Powers of attorney and healthcare directives allow someone you trust to take care of you and make choices for you when you're the most vulnerable. Without these, the court will choose who they think is best to serve you. Having a plan in place will save your family from guessing and fighting about what you would have wanted when making those hard decisions. Take the stress and the guesswork out of it. There are a few more documents you may want to have in your estate plan. Call me, I'll create a customized plan for your significant other and your family won't have to go through a contentious, lengthy probate. I'm Ann Hart. You can find me at hartlawpllc@estateplan.com or email me at hartlawpllc@gmail.com. Thanks for listening.